I know that everybody wants to get out of here as soon as they can. We've had a tough week. But this is a big bill, and I want to do the best we can to get it right if we're going to pass any form of it. The journey it has to take is Monday. It will come before the Courts of Justice Committee or the Judiciary Committee, and then if it gets through there, it will have to go to it'll have to go to Finance by Wednesday, and so that is a very short window for any possibility of success. So with that in mind, I kind of want to think through the criminal portions of this bill, and based on some decisions we made the other day, I asked Senator Servell to come up with an outline of things that he thought we ought to take a look at, and we've kind of passed that around by email. It's gone to a couple of people, and so I guess we need to think through some questions really quickly if we're going to be able to move forward, and we do want to move forward. The first thing I want to talk about are the expungement provisions of the bill. Is Charles, are you online?
Yes, Mr. Chair, I'm here.
Okay, the expungement provisions begin where?
So the expungement provisions begin on lines 1188.6, so 11,886. And it's at section 19.2, 392.2:1.
Okay, that's on page 238.
Former marijuana offenses, automatic expungement.
Okay, that's on page 238 of the bill. What we're talking about are automatic expungement for possession of marijuana, for possession of paraphernalia, and for misdemeanor, possession with intent to distribute. That's possession with intent to distribute very small amounts.
Mr. Chair, I believe you're muted, or at least I can't hear you on Zoom, so.
Okay. Well, all the expungement part starts on page 238, line 11,805. And what I'm thinking about this and other expungement legislation that's passing through this body, it seems that some automatic expungement makes sense. If we're taking offenses off the books, there ought to be automatic expungement for simple possession of marijuana. For conviction of that, there ought to be automatic expungement for simple possession of marijuana paraphernalia, and there ought to be expungement for other misdemeanors. The misdemeanor of possession with intent to distribute. That's intent to distribute a very small amount. Am I making sense? Do you all have other ideas about that?
Mr. Chairman?
Senator Eben.
I'm not a member of the committee, of course. I'm just one of the sponsors, but I did want to point out that the National Organization for Reform of Marijuana Laws and the side-by-side that I distributed to you mentioned that we should include hashish as well, since that was formerly a charge that people have been convicted of.
That's correct.
Hashish? Okay, that's on the bottom of the first page of the side-by-side.
Yes, it is.
Okay. Automatic expungement part of this bill begins over on line 11,886 on page 240. Charles, how does this play into the various expungement bills that have gone through this committee?
Mr. Chair, this doesn't conflict with any of the bills that have gone through. This would just provide a automatic expungement for the marijuana offenses that you mentioned, the misdemeanor distribution, the paraphernalia and any possession. They don't conflict all the bills before the Judiciary Committee contemplate expunging these charges. So there is no inconsistency. This would just provide for an automatic expungement sooner under this particular bill than provided in the expungement bills that we've seen. So if this was to move forward, I think that the expungement provisions could be easily reconciled.
Okay. Well, the question is, do we want expungement by petition for anything? I mean, for example, under current law, if you possess a firearm at the same time you possess certain drugs, you get an enhanced penalty. Should there be an expungement by petition process in that situation?
I believe there is that included in the bill for the felony marijuana charges, that they would have to petition the court.
Mr. Chairman.
What line that's on?
I'd have to ask one of the experts of the administration. I'm flipping through.
Mr. Chairman, it should be in 19.2390 point something if it's with the rest of the expungement rules.
Well, that's what we've been looking at, Senator Servell. We're looking at the automatic expulsion over on 19.2392.1 colon.
Right. So, Mr. Chairman, I think if you look at line, in the book I'm looking here, it's line 11809. That expands the expungement process for people adjudicated delinquent of felonies or convicted of a felony marijuana distribution.
And
Mr. Chairman, at least I would note that code language is inconsistent with the practice that this subcommittee endorsed. What was it, yesterday or the day before? Because what we endorsed before was that for convictions we have a sealing process and not an expungement, and there's a material difference.
As I recall, with the expungement bill, what we did, we took that piece of your bill, put it together with the piece of Senator Lucas's bill that dealt with third-party liability or commercial liability.
That's correct, Mr. Chairman.
Mr. Chairman, yeah, that's correct. And I would add to what Senator Stovall is saying is it is only the conviction of the felony is what is inconsistent.
Mr. Chairman, sort of. The bill that we passed, or the bill that we recommended for reporting and referring to finance on expungement would create a sealing process for felony convictions, not an expungement, but a sealing process. So we did endorse the idea of...
So your argument, Senator Servell, then, is that this bill is inconsistent when it comes to felony convictions with the bill that we passed out of here yesterday?
It's similar but inconsistent.
Correct.
But Charles, to your point, those inconsistencies can be reconciled as we work through the process.
Correct, Mr. Chairman.
Okay. You had another question about this process, Senator Servell, that had to do with making sure that police officers receive immediate training on drug recognition.
Yep, Mr. Chairman, I know last session we made a whole series of changes in police training rules pursuant to Senator Locke's Senate Bill 5030, and we added a whole bunch of new training requirements. And it occurred to me that if we're going to be heading in the direction of legalization, that we probably ought to beef up our training of law enforcement officers when it comes to drug recognition or marijuana, the recognition of marijuana impaired driving. And I was asking the question as to whether or not we want to make any code changes in those training sections about that issue.
I would ask, were you in the room when Senator Evans pointed out that it probably would be consistent with what we're doing to make this expungement provision apply to convictions of possession of hashish as well as marijuana?
Is that a question of me, Mr. Chairman?
It is a question of you. I'm wondering if we need to if that needs to be included in the education, I mean, I'm not sure what the difference is between hashish and marijuana.
Potency, Mr. Chairman.
Potency? Same
Yeah.
stuff, just potency.
Yeah. Mr. Chairman, last year, the decriminalization marijuana bill, hashish was eliminated as a separate controlled substance, and it was treated all the same as marijuana, which is where I think that this is stemming from. Is prior to the decriminalization, hashish had treated as a separate substance, not as marijuana. So there was a different conviction for it.
Okay, well, what do we need to do to make sure that if hashish is indeed cannabis, what do we need to do to make sure that convictions of hashish can be expunged the way that convictions of marijuana are?
We would need to include in the expungement, wherever you want them to include it, either as a petition or as the automatic section, just a reference to the former controlled substance violation involving hashish.
Okay.
Mr. Chair,
The
Mr. Chair,
Senator McClellan.
if it helps, I just did some quick research, and hashish and marijuana both come from the cannabis plant. It's just a different part. So in its simplest form, weed is the dried, unprocessed flowers of the female cannabis plant, and hashish is the resin of the female cannabis plant that hasn't been separated from the plant itself through mechanical or chemical means.
Okay.
So they're both cannabis.
Okay. Is there consensus that we want to add that to the expungement? Do we need to amend the bill, or is there consensus we can get together around that issue?
I'm sorry, Your Honor. Mr. Chairman, can you frame the issue a little bit?
Well, the issue is that if we ought to treat convictions for the misdemeanor possession of hashish the same way we treat misdemeanor convictions of marijuana. They're both cannabis. And if we're expunging one, we ought to be able to expunge the other. That's the point raised by Senator Evan.
Right, Mr. Chairman. So just so I'm clear, and I was outside for a few minutes, and I'm trying to figure out exactly where we are on what we're repealing. I know Senator McClellan had previously moved that we recommend.
Well, I'm sorry, and I apologize. I didn't go in the order of your outline. I just started talking about expungement because that was related to a large extent to what we did yesterday with the other bills. I wanted to get that out of the way. And that's what I started with.
Well, Your Honor, Your Honor, Mr. Chairman.
Senator Servell.
Sorry about my lawyer tick. I can tell you that my inclination is that any misdemeanor statute that we repeal, any prior convictions ought to be automatically expunged. I start with that principle. Any felony convictions that would no longer be felonies, I believe, ought to be eligible for petition-based sealing. That's at least the concept in my mind that I think we ought to approach all these issues with.
What do other members of the subcommittee think? Does that make sense? If conduct that was once a misdemeanor is no longer a misdemeanor, no longer a crime, it ought to be subject to automatic expungement. If conduct was once a felony is no longer a crime, it ought to be subject to expungement of a petition. That's Senator Servell's point.
Or sealing.
Or sealing, yes.
Well, Mr. Chair.
Senator McClellan.
And maybe I missed this or forgot this from the discussion yesterday, but why? Why the distinction? If the felony is no longer a crime, why would you need to petition for expungement?
Mr. Chairman.
Senator Servell.
Because because it's a felony, and B, because if we're talking about drug distribution, there are many different species of drug distribution. Some PWID, possession of marijuana with intent to distribute, are relatively minor. You can get a PWID for having only more than an ounce of marijuana, and I don't consider that to be significant. But there's other PWIDs that could be involved, have a much higher quantity involved. which involve people in significant operations or could have weapons involved or other aspects of the transaction that I think a Commonwealth attorney might want to weigh in on before a judge decide that it's worthy of being sealed. So I just think felony behavior needs to be treated a little more carefully than misdemeanor. That's where I come out.
Mr. Chair.
Colin?
Well, I guess where I come out is anything that is no longer a crime going forward, and people who engage in the exact same activity face no criminal penalty for it, then it should be automatically expunged for people who did it before it was no longer a crime, whether it's a felony or not.
Senator
Mr. Chair.
Servo.
Yeah, I think perhaps the difference is that marijuana distribution, no matter what we do, is still going to be a crime if you do it without the correct license. It's going to still be a much more highly regulated activity. It's not going to be as serious of a crime. I believe it's going to be treated more like a misdemeanor if you sell marijuana without a license from the state. So I would just point that out. But I think if somebody's caught with 100 pounds of marijuana, I don't think they should get an automatic expungement. I mean, that's
Not everybody's spoken yet, Senator McClellan, but I would tend to agree with that, at least from the standpoint of being able to move forward. If we can agree to treat misdemeanors and felonies differently.
I mean, it's majority vote, so.
Okay. Let's move on to the next issue, if we can just for now I think Senator Evan.
Just to point out, yesterday you heard testimony from, I believe it was the Supreme Court, that with the automatic expungement, that the date of July 1st, 2021 would not be workable for them. So you may want to consider the date.
Here's what I'm thinking. The automatic expungement is going to take 4 years to do. We're basically involved in a 4-year discussion. If we make the investment now of about $10 million, we can have automatic expungements for even misdemeanors done in 2025. If we can agree right now by consensus or by majority, by vote, to treat misdemeanors and felonies, I'm not sure that this argument is worth holding the whole discussion up, the whole bill up, in other words. I want to go back to something we talked about, Senator Servo.
Sorry, Mr. Chairman. It sounds to me like you're trying to move on from the expungement discussion. There's a couple other issues I wanted to bring up.
Okay.
First of all, my reading of the new automatic expungement statute 392.2:1 would indicate that well, first of all, I had a question for counsel. It seems to include, within automatic expungement, 18.2265.3, which I believe is possession of paraphernalia as it relates to marijuana. Counsel, is that correct?
That's correct, Mr. Chair.
Mr. Chairman, next question for counsel is, does counsel know whether it is possible for the Supreme Court or a circuit court clerk or anybody to ascertain whether a conviction of 18.2265.3 relates to marijuana or some other type of drug simply by looking at the record?
Mr. Chairman, that was what I brought that up. That is a problem in terms of automatic expungement.
Okay.
Because one, they probably can't figure out if it relates to marijuana, and two,
Got it.
has difficulty expunging, automatic expunging according to subsection.
Got it, Mr. Chairman. Then, Mr. Chairman, and that's kind of what I suspected, and I would say that in light of that, and at least in light of my experience in my jurisdictions, and I don't know about everybody else's jurisdictions, I would suspect that about 95% plus of the convictions under 18.2265.3 relate to marijuana situations, that we simply strike the language as it relates to marijuana, because I don't believe having that language in there makes this workable. And I think that, the risk of it picking up other types of paraphernalia, whether it be heroin or cocaine or something else, is relatively low, because I'm not sure if I've ever seen it charged or pleaded to in any situation other than, well, I guess there might have been a cocaine or possession or something where I saw somebody plead to paraphernalia, but Senator McDougal or Stanley might be able to have more experience with that, or maybe you, Mr. Chairman, but or Senator Morrissey, but
Mr. Chairman, most of the time under paraphernalia, people aren't charged. It's
Plead.
you're given the option, and so sometimes it's marijuana, sometimes it's something else. I think you see it in non-Schedule 1 and Schedule 2 drugs.
I guess, Mr. Chairman, the question
The majority of the time.
the question I think for the committee would be, do we feel
You're correct. There's no way to look at a warrant and determine what the underlying substance
So, Mr. Chairman, it seems to me the question for the committee would be, do we feel comfortable automatically expunging all prior convictions for 18.2, 265.3 that would have occurred before the date marijuana possession is repealed? Or do we just want to take paraphernalia out of the automatic expungement piece and leave that for the other expungement discussion?
Mr. Chairman.
Senator Morrissey.
Mr. Chairman, I, for one, am comfortable with expunging it all. Here's what I think it boils down to. A significant percent, perhaps 90% or more, under 18.2265 at SEC involves marijuana. We all know that it will never occur that you will scour every warrant, every record to determine exactly what it was. And my position is expunge it, and so what if you capture a little bit more than what you intended? We're getting, I think, the most accomplished by expunging it if there's a conviction under that code section, and not worry about, because if we leave that code section in there, there's, as Senator Serval said a few moments ago, many, many people that were convicted of a marijuana-related offense under that section. So, and we don't want to do that. So let's just take it all, expunge it all. And I'd like to get a flavor of the committee, a sense of the committee of what they think.
Mr. Chairman?
Senator Serval.
And I think Senator Morrissey has grasped the crux of the issue. The issue is whether or not, and I agree with him, that there's a lot of marijuana possessions that are pleaded to paraphernalia because people were looking to avoid a license suspension at the time. They didn't want to go through a 251 program and all the testing and everything. So there's a lot of paraphernalia convictions that are really former marijuana possessions. But by expunging all prior paraphernalia convictions, we're probably going to pick up some cocaine, some heroin, some other types of charges that maybe got pleaded to that. And the question is whether or not the committee is comfortable bearing that risk, and we just want to start with a blank slate, or whether we want to leave discretion in looking at those convictions. That's the issue before us. I think Senator Stanley was starting to say something a minute ago about it.
Stanley, did you?
Well, Mr. Chairman, can I add something to it?
Senator Morrissey.
At the end of the day, a prosecutor and a defense attorney and a judge agreed that it was a paraphernalia-related offense. All right? I don't care what the initial facts were. It's a paraphernalia-related conviction. If that's the case, and we have a mindset right now that we're going to expunge marijuana, aren't we all in agreement, and we're in agreement that we should expunge paraphernalia cases? Who cares what it started at?
Mr. Chairman.
It was a final conviction for paraphernalia.
Senator Morrissey, if we know that marijuana is the drug involved, that's an easy question, it seems to me. But we don't know. That was part of the discussion right now. You know, we don't know from looking at the paper necessarily. We don't know from looking at the warrants or the court record whether it's marijuana or whether it was cocaine or methamphetamine. We don't know from a straight paraphernalia case.
And Mr. Chairman,
Senator
Mr.
Stanley.
Chairman, yeah, and you know, if you look at the paraphernalia statute, it does not even have paraphernalia that would be marijuana. There's no reference to marijuana paraphernalia. We sometimes reduce it in marijuana cases because there's no real adequate misdemeanor that would not have at the time taken away your driver's license before we corrected 18.2251 for first offense. And when there's subsequent offenses, in order to save that person if it was a subsequent offense, but they had a little bit of marijuana, but they were going to lose their license, then we would knock it down to there. But paraphernalia, in its form, it talks about needles and things that are used for other more potent drugs. So I get a little bit, I think we could do well as a General Assembly to amend the paraphernalia statute to include marijuana-type devices. But I think, quite frankly, there are times where we've used it when paraphernalia has been found in meth cases, and cocaine cases, and crack, and or they find a crack pipe. There's no active crack in any bag or anything, but they test the residue of that pipe in it, and it's needles too, and they find just enough there, but it's not enough in terms of giving somebody a felony charge. So you give them the paraphernalia charge.
Along that same point, Mr. Chairman, a quick point.
Senator Morrissey.
It's not just needles associated with Schedule I and II drugs. Possession of drug paraphernalia also includes those items used to ingest marijuana, we call a bong or a marijuana pipe. Many people have been convicted of possession of drug paraphernalia for those implements.
Senator Morrissey, I would say that in my practice, I've not seen anybody convicted of anything like that for 20 or 25 years. What I see in terms of paraphernalia now is primarily stuff that's used to ingest
I agree.
Methamphetamine or heroin.
I agree.
From a consensus standpoint, it seems to me that if we can say that the conviction of the paraphernalia statute is clearly related from the court record to possession of marijuana, that could be expunged. But otherwise, leave the rest alone for right now. There's a bill in the other body that would decriminalize possession of drugs and writ large, all narcotics. Well, if that bill passes, then I think paraphernalia ought to be expungible.
Mr. Chairman.
Yes, Senator Servo.
I would just note for the committee, however, that Section 18.2.265.3 also includes a felony offense and another misdemeanor offense having to do with distribution of paraphernalia to minors by adults. And so we need to be very careful because I don't believe the way it's worded right. Oh, it's subsection A right now, so the felony and the minor piece is out. So it's only subsection A. I'm not even sure that I've ever noticed that they convict of a specific subsection when they actually enter the conviction. I guess you could, and there's two different Class 1 misdemeanors, so you can't distinguish between subsections A and C if they pick misdemeanor. I'm a little worried about how workable this is if they actually do it. It was originally, I think, actually my idea to stick it in here when I was talking with the work group because I've seen so many marijuana possessions pleaded to paraphernalia, but I'm worried about the workability of automatically expunging
Mr. Chairman, and Senator Strovo's correct. There would be difficult because the burden is on state police to determine which of these charges would be eligible for automatic expungement. Sections where there are mixed penalties, it will be very difficult for state police to determine if they are eligible for automatic expungement. Obviously, the easier fix, and I realize may not be a desirable policy decision, but would be to make these eligible by petition. So this way the petitioner would then would bear the burden of showing that they are eligible as opposed to state police determining what is or what is not expungible.
Mr. Chairman, question for counsel.
Senator Morrissey.
Either for Charles or Mr. Benjamin, would staff not agree that many people who are in possession of marijuana were offered in the past to be treated more leniently than being convicted of simple possession of marijuana, that they availed themselves of and agreed to plead guilty to possession of drug paraphernalia? Would you both not agree that happened quite frequently?
Mr. Chair, I would say Steve is not here today, but I think Steve would agree that does happen. I've seen possession cases that get changed to a reckless driving, or something of another misdemeanor or lesser misdemeanor. So Senator Morrissey's point is correct.
So, Mr. Chairman,
Senator Morrissey.
I heard Charles say that perhaps that would be an avenue for specific petition. However, You and I and everybody in this committee knows that folks that have had that conviction of paraphernalia when they possess marijuana are not running out to the Stanley and Servilles and Deeds and Edwards and McDougalls of the world and saying, please go file a petition to expunge my record for possession of paraphernalia. I would rather capture a larger group than intended than a smaller. I made my point clear. I won't say anything more.
Mr. Chairman.
Senator Servo.
Thank you, Mr. Chairman. So I can appreciate Senator Morrissey has been very passionate about his interest in expanding the expungibility of all kinds of offenses and having as broad a net as possible with regard to expungement, making it as automatic as possible. And I feel like we've made a policy decision that we're not quite ready to go quite that far yet. And so, but I appreciate his passion on it. But I don't get the sense that the committee is really in that place. And so what I would suggest is that we strike the 18.2265.3 language from the automatic expungement piece. And I would also ask if council could also include language in the petition-based expungement statute 19.2392.2 indicating that if the petitioner shows they're charged with a violation of 265.3, that they shall be entitled to an expungement provided they demonstrate in court that the original charge was either marijuana possession or that marijuana was, that the paraphernalia involved in the situation was marijuana, something to that effect. That way that person would be entitled to a petition-based expungement and the court would have no discretion about it. That would be my motion, Mr. Chairman.
Okay, I think I understand the motion. Is there a second? Is there a second for that motion? I'll second. Got a motion and a second. Any further discussion? All in favor say aye.
Aye.
Opposed? No. Opposed, no. Okay, we're going to amend it that way. Okay.
Mr. Chairman.
Senator Servo.
On expungement, the other difference between this and the expungement bill that or at least one sort of difference between this bill and the bill that we recommended is that I believe under this bill there's no confidentiality of the list of charges that are reported from the courts to the state police for purposes of the automatic expungement. And I believe it's critical that when a court transmits the list of the charges that are to be expunged, that list be sealed. There's been situations, at least in my jurisdiction, where certain parties with nefarious intent have basically taken information about criminal charges and posted them on Google so they can be accessible by a Google search. So, for example, you could search Cree Deeds or Scott Surivel, and it would pop up on Google that you had a charge somewhere. And this expungement data is particularly subject to being used for extortion purposes, especially on the internet. And I think it's very important that this list be kept sealed and only accessible to law enforcement until we have further discussion about how to release that data to anybody else. And so I would ask council to prepare an amendment to that, and I would move that amendment.
Charles, did you get that? Did you understand what he was saying?
I did, Mr. Chair. I believe Senator Servo is looking for the same language that was in his expungement bill regarding the confidentiality of lists that are prepared for automatic sealing in his bill or automatic expungement in this particular bill.
Okay. Well, you've got Senator Servel's amendment. Is there a second? Okay. Any discussion? All in favor of that amendment, say aye.
Aye.
Opposed? No. The amendment's adopted. Okay. Is that all the expungement? Is that the expungement issue of this bill? Then what I want to go back to is an amendment we adopted the other day to allow simple possession of marijuana to be legal as of July 1.
Mr. Chairman, I'm sorry.
I'm sorry, Senator Servo.
Again, the other difference is that this bill causes expungement and not sealing of felonies, and there's a material difference, and I'm not really sure that kind of reconciliation requires much more significant surgery. And perhaps that's a discussion for another day. I mean, it's similar in intent, but different in practice and in consequence. And
What I'd suggest, Senator Servell, is that, as you indicated, that's going to take a considerable amount of surgery to make that change in this bill. And if you have a specific way to do that, to make that reconciliation, maybe present an amendment, come up with an amendment by Monday, and we'll take it up in full committee when we have this bill.
Okay. That's it.
Okay?
Mr. Chair, before we move off expungement, I do have an amendment to the expungement language from the administration.
Okay.
I'll say some difficulty in automatic expungement for state police to determine if all costs are paid. So on line 11,892, it would recommend striking, including satisfaction of all court costs, fines, and all orders of restitution, and adding in language to reflect any order to automatically expunge an arrest, criminal charge, conviction, or civil offense shall not relieve the person who is the subject of the order of any obligation to pay any fines, costs, forfeitures, penalties, or restitution in relation to the offense that was ordered to be automatically expunged.
Okay.
Chairman, that's a great idea, but how the hell are you going to do that? So if you're expunging the record and it's gone away so that nobody can have access to it, then how are you going to know what the restitution is and to who it is? Now, we do have a restitution order today, but that's only been for the last couple years. Typically, that was written on the summons or the warrant, and certainly all the court costs. I mean, if you're supposed to destroy all those things, how now are you having a record of it?
Very good question. Charles, do you know the answer to that?
Maybe the Supreme Court can tell us what magical potion they're going to bring in to keep track of all this without actually keeping track and destroying it.
It's probably not fair to ask Charles to answer that. If there's someone from the administration on the line, on the call, who can explain that amendment and how it's workable if we're expunging the record.
Yeah, I'm happy to address that. Jacqueline Katoon, Assistant Secretary for Public Safety. Good afternoon, Mr. Chair, members of the committee. So the issue that we have identified and the reason that this amendment was brought forward, when we spoke with OES and with state police about expunging records where the previous language required that an individual had paid all of their fines and costs prior to automatic expungement being implemented. Effectively, there is no way to tell in an automatic system whether or not an individual has paid off their fines and costs. So what we decided to do is include language to remove that requirement prior to expungement. And then this language was put in to clarify that the expungement did not remove the person's liability to pay those fines and costs.
But I think Senator McDougal's question, his point was, once the record's expunged or sealed or whatever, what record exists that there is some debt to the Commonwealth or some third party?
So that is a question that I would defer to either the courts or VSP. I don't have a specific answer on that one.
Okay. Is there anybody else that wants to try to address that? Anybody that's online? Is the Supreme, yes, I don't know. Is the Supreme Court there? Christy Wright?
Yes, Mr. Chair. This is Eileen Longenecker with OES at the Supreme Court.
Okay.
Typically, expungements apply now to not guilty, dismissal, acquittals. And so there are no fines and costs, but for convictions, there would be fines and costs.
Yes, ma'am.
And typically, everything gets deleted from the system with an expungement.
So once the conviction is expunged, any record of fines or restitution would disappear as well. Is that correct?
Correct.
Okay. Is there a motion to adopt the administration's amendment to change that language?
So moved.
Is the motion seconded?
Mr. Chairman,
Senator Morrison.
I'm sorry, and I might be the only person that doesn't. I've read this twice now. The administration is suggesting striking on lines 11, 8, 9, 2, the words, comma, including satisfaction of all court costs and fines and other orders of restitution. That's what they're suggesting be
But
struck.
they want a new language that says, that says even though it's not going to be required to be for the expungement to occur, it's not that the obligation will still exist. But the amendment basically is doing away with any record of the obligation.
Okay, all right.
So Senator Edwards made a motion. Is there a second?
Second.
Okay, any further discussion? All in favor of that amendment, say aye.
Aye.
All opposed? No. No. Okay, the amendment's defeated. Is there anything else with expungement? Okay, I want to return to an issue we took up the other day, and that's to make simple possession of marijuana legal on July 1 of this year, which, the bill is introduced, said January 1 of 2023. As it came out of Rehab and Social Services, it said January 1, 2024. We adopted an amendment, and I voted for it. The amendment would allow simple possession to be legal as of July 1 of 2021, even though the market and the regulatory scheme which we are setting up wouldn't be effective until January 1, 2024. And I just think that we ought to think about whether that makes sense.
Mr. Chairman,
Senator Servo.
first of all, I agree with the intent, but I think the decision is a whole lot more complex and nuanced than what we assumed at the moment we made that decision. And so, in order to get this in a posture where we can, I think, consider the complexity of this, I'm having voted on the prevailing side by which we adopted that motion. I would move that we reconsider that vote.
Okay, Senator Servel's made a motion to reconsider. Is there a second? Okay, got a motion and a second. Any discussion of that motion to reconsider? If not, all in favor of reconsidering, say aye.
Aye.
Opposed? No. Okay, that issue is back before us.
So, Mr. Chairman,
Senator Morrissey.
so the issue that's now before, since it's been reconsidered, is Senator McClellan's motion that, notwithstanding all the other various moving parts, at least that portion that legalizes simple possession of marijuana of up to 1 ounce be enacted into law on July 1, 2021. Is that Senator McClellan's
That was her motion. That was her motion.
Okay, and that's what we're reconsidering.
That's what we've reconsidered. It's now before us.
Yes, okay.
I asked Senator McClellan this when we were walking over here, and I don't mean to be unfair to her because she wouldn't have any more of an idea to know this than I do, but somebody on the line might. How many? Since July 1 of 2020, marijuana simple possession has been decriminalized. It's subject to a $25 civil penalty. At least in the part of the world where I practice law, where I live, the fact that there are no court costs at all associated with that have taken out the incentive for writing those tickets, and so they aren't being written. And I just wonder how many tickets have been written around Virginia since July 1, 2020 for possession of marijuana. Does the Supreme Court have that information? Is there anybody on the call that would have that information? Christy Wright.
I'm sorry, Mr. Chairman. What was the question again as to what we would have?
Since July 1, 2020, we decriminalized simple possession of marijuana, small amounts. It's subject to a $25 fine with no court costs associated with it. Do we have any information on how many tickets have been written for simple possession of marijuana since July 1, 2020?
Yes, I believe I do. I'd have to find it in my information that I have. I don't have it at the tip of my tongue, but I can look for it and get right back to you.
I would appreciate that. Would you be able to have any idea right now in a ballpark figure how to quantify that, whether it's been in the hundreds or the thousands or just a handful?
As far as the charges for us on the civil penalty, I believe it's been in the thousands.
Okay,
Yeah, and I'll send it to Charles.
okay, I appreciate
Mr.
that.
Chairman,
Mr. Chair.
Senator Serville, then Senator McClellan.
I'm sorry, I would also just ask if Ms. Wright could also give us some context so we can compare whatever statistics she's going to give us with a similar period before we took the action we did effective July 1.
Did you understand that?
I did. I'll see what I can come up with short notice here.
Okay, thank you very much. Senator McClellan.
Yeah, Mr. Chair, I guess I would like to see what the data is for before July 1, at least a 3 to 4 or 5 year period, because as I understand this bill, if we, by undoing my amendment, then it would be still unlawful and they could write tickets until at least 2023. So just because there haven't been very many in 6 months, doesn't mean there may not be many more going forward to 2023, if I have gotten that enactment date correct.
Well, what is just curious to me, at least where I live, law enforcement they don't feel incentivized to write the tickets. They aren't writing tickets
Mr. Chair.
because there aren't any costs associated.
Mr. Chair, with all due respect, I think that might be different in other parts of the state.
Well, I understand. I want to know what those differences are, why they exist.
Mr. Chairman,
Senator Morrissey.
with all due respect, I think, and I think that your approach as to looking as to whether or not there have been charges, I think we're missing the mark. By analogy, we once made it a felony for people to engage, two people of the same sex to engage in consensual sodomy. I don't care that it was never ticketed or prosecuted, or there was only 1 in 20,000 cases. That misses the mark. Right now, there is a sense, we're doing the people's business, there is a sense that marijuana, simple possession of marijuana should be legal. I don't think we should be looking at whether or not there have been a lot of tickets written for civil tickets for possession of marijuana. If that is our feeling, if that's the will of the people, then I think we need to support Senator McClellan's amendment to decriminalize and to legalize simple possession of marijuana and do it as soon as possible, notwithstanding Senator Serville's comments that there are a lot of other moving parts.
Does that, would you also support the ability of one to grow their own plants by July 1, 2021? Or would you say that we continue to support a black market before we allow this legal market to open on July 1, 2024?
Mr. Chair.
Senator?
Well, if you were asking me a question, let me answer. I'd like to answer that first.
Sure.
I want to make sure that somebody that is traveling and has an ounce or less of marijuana on their possession, okay, and is stopped by the police, is not given a civil ticket for small fine. That's what I'm saying.
Okay, that's fair enough. Senator McClellan.
Mr. Chair, same. We already, as a policy matter in 2020, said that we made a moral decision that simple possession of marijuana should not be punished going forward criminally. But by keeping in place a civil penalty, we have kept in place the potential for what we already know is happening for simple possession to be disproportionately enforced. And so I wanted to do it. I think Senator Morrissey wanted to do it. I think there were other people who wanted to do it in 2020 to just go ahead and end the prohibition on simple possession in 2020. I don't want to wait until 2023 to do that, when we have already made the moral decision that simple possession should no longer be a crime. So now if by simply repealing that section has caused an issue, there may be other ways we can get at it. But it seems to me, as of July 1st of this year, simply possessing marijuana should not subject you to a $250 fine that we know
A $25 fine.
any kind of fine, that we know is going to be disproportionately enforced because it's already been disproportionately enforced in the past when it was a crime.
Mr. Chairman.
Senator Surville.
Thank you, Mr. Chairman. And first of all, I would say to Senator McClellan that I support what she's trying to do, and I agree with both her and Senator Morrissey. However, the issue is by doing that, there are a series of consequences that flow from it, which we must account for in connection with doing it. For example, possession of marijuana by a school bus driver needs to remain illegal. Possession of marijuana by a commercial vehicle operator has to remain illegal, or else we lose federal highway safety funds. There's also the issue about plants in people's house, and we have to decide exactly, what to do about a plant out back that I think probably meets the felony threshold or whatever the new crime threshold will be if we legalize. And so in order to do what the senator wants to do, there's a bunch of other issues we have to discuss in order to accomplish it without creating a whole panoply of unintended consequences. So that's the point. That's the reason I asked that we reconsider it, is so we could talk through those issues as well in order to accomplish what you want to get done.
Mr. Chairman.
Senator Morrissey.
I always appreciate Senator Serval's points, but let me just say this, and I think it distills down to the following. Senator McClellan wants to legalize it now because that's the will of the people. Senator Serval says no because there may be some unintended consequences.
No, I don't. That's not what I said.
Okay. Well, you're saying that there may be some people that we still want to make it illegal, like bus drivers or manufacturing. Here's my point, Mr. Chairman. Let's say somebody is cultivating, raising 2 or 3 marijuana plants. Here, let the police do whatever they're going to do. Charge that person with a felony cultivating, growing marijuana. Have at it. But what Senator McClellan's amendment would do would put an end right now to that situation that I described earlier, the pedestrian case of simple possession of marijuana. That's it. I think that's it.
And as I heard Senator Serval's last point, he doesn't necessarily have a problem with that. His concern is that you're also going to legalize possession. When you just do it as simply as that, you are legalizing possession of marijuana by someone who drives a school bus or someone who is a commercial truck driver.
Mr. Chair.
Senator McClellan.
So how did we handle that in refresh my memory, Senator Serval, how we handled that in the decrim bill? Are those, if a bus driver has marijuana, is that decriminalized and $25 fine? Or is that still a crime? I just don't remember.
Mr. Chairman, I would say to Senator
Serval. I don't remember either.
I don't remember either, but I know it's in here, and there's a new statute with regard to bus drivers. There's also a new statute, I believe, with regard to school property. And I believe there's, I don't remember if there's a statute with regard to commercial vehicle operators.
There'll be an amendment on that, sir.
Okay, but my point is that it all kind of ties together. And I'm not sure, and I think we probably need to do some surgery to, again, fix the plant growing at home issue somehow. And I'm not even sure how to fix that, but we have to talk about it. It's in here somewhere, and I'm trying to find it.
While he's looking at that, Mr. Chairman, can I ask Senator Serval a question?
Senator Morrissey.
Did I understand you to say that you still want to consider the person that's growing a couple of plants at home? Is that the last thing you said?
If it's more than the amount that we are going to legalize, I think we have to talk about it.
Under the proposal, I think one can have 4 plants, 2 mature plants and 2 immature plants at home. Isn't that correct, Senator Evans, Senator Lucas?
Mr. Chairman, can somebody tell me how much marijuana a plant generates in terms of weight?
It varies.
The mature plants can be 6 or 8 feet tall, can't they?
No, weight, ounces.
Okay. Smokable material you're talking about?
Yeah. Mr. Copenhaver.
Yeah, Mr. Copenhaver, can you answer that question?
Mr. Chairman, I think Mark Gribben from JLARC is prepared to answer that.
Great, that's great. Mr. Chairman, Mark Rubin with JLARC. In our report, we did some estimates. The long story is that it can vary significantly depending on the plant and how good of a gardener is growing it. But we estimated that 2 marijuana plants, so that would be the 2 mature plants that are contemplated in the bill, can produce, excuse me, Mr. Chairman, I'm on the wrong page. Could produce, typically yield about 8 to 16 ounces of marijuana per year, which we estimate would be enough for a moderately heavy user.
8 to 16 ounces a year out of each plant or out of the 2 plants?
Mr. Chairman, from the 2 plants. So to get the single, just divide that in half.
That's half a pound to a pound, Mr. Chairman.
Mr. Chairman?
How much does, how long does it take for a plant to mature? If you've got 2 mature plants, how long does it take to, and do plants age out, or are they seasonal? What, they perennial or seasonal, or what's going on with these plants?
Mr. Chairman, I don't know if we have any of the folks from the industry on the line. They may be better able to answer that. My general understanding is anywhere from 6 to 9 months is a life cycle, maybe as much as 12, but I'm a little out of my element in terms of the horticultural side.
Mr. Chairman?
Senator Morrissey.
Having visited Greenleaf, I think they, to use your expression, I think they age out. But let me put things in perspective. I prosecuted for 7 years. For every 1,000 cases of simple possession of marijuana, you may get the person who's cultivating a couple of more plants in their backyard or in their greenhouse inside. So if we don't adopt Senator McClellan's amendment, okay, we are going to continually criminalize thousands of people because we want to prevent, because we're worried about allowing the 1 or 2 individuals that are growing marijuana at home to escape.
Hold on
Seems to be nonsensical.
Senator Morrissey, so you're proposing that you extend her amendment to allow people to grow at home as of July 1 this year?
No, that's not her amendment. Her amendment is to legalize, to legalize the simple possession of marijuana, up to 1 ounce. And we keep talking about this growing it at home. We're forgetting the fact that the police or prosecutor could still charge the person with a felony possessing marijuana or cultivating marijuana with the intent to distribute it.
And if Christy Wright's still there, I would appreciate some information if you could give us on those people that have been charged with manufacturing marijuana in the last year as well.
Mr. Chairman.
Senator Servell.
Thank you, Mr. Chairman. I found the school bus statute.
Okay. How did we handle the truck drivers and bus drivers and decrim?
So, Mr. Chairman, I would just note that I believe there's at least a couple statutes here that would also need to be effective the same date, July 1 of this year, if we were to do that. So if you would turn to lines 7891 in your book. $78.91. The first statute, I believe, would be consuming or possessing marijuana on public school grounds. I think that statute, that new statute, 4.11109, probably ought to go with it, Mr. Chairman. And then secondly, I would say the next statute, 4.11110, which is possessing or consuming marijuana products while operating a school bus. That probably ought to be tied to the motion. In addition, I believe that at 7909, 4.11112, which has to do with possessing marijuana in a motor vehicle transporting passengers for hire. I believe that one might also be one we'd want to consider. Yes, sir. 1112.
I do have some numbers, and along with those lists that Senator Servell and maybe intentionally excluded, lines 787 to 790, And normally bring it to the committee's attention because that's also consuming marijuana in a public place. I don't know if you'd want to include.
Could Charles repeat that, Mr. Chairman?
787 to 790, he said that,
Consuming marijuana in a public place. That's right before the public school grounds. It's a class 4 misdemeanor. I'm just bringing that to the committee's
Mr.
attention.
Chairman, that would be consistent with, I believe, consuming alcohol in public as well. And if we're going to be consistent, it would be consistent.
Now, Mr. Chair, I got some numbers from the court.
okay,
And they broke them down by jurisdiction in terms of which court it is. So for charges for simple possession of marijuana, in general district court, there were 4,505 charges, of which 1,848 were guilty of the charge. In JNDR court, there were 141 charges, of which only 13 were adjudicated delinquent. And in circuit court, which excludes Fairfax, Alexandria, 28 charges, of which 1 was guilty. I do have some historical numbers, at least.
okay, that first set of numbers is the number since July 1 of 2020?
Correct.
Okay.
And these are some historical numbers that are not broken down, just number of arrests. In 2019, there were 26,470 arrests. In 2018, there were 28,866. And in 2017, there were 27,852 arrests. And in 2016, it was 21,637 arrests. So it is a substantial decrease since July.
Mr. Chairman.
Senator Servo.
Thanks. So, Charles, the number you gave us, the 4,000 charges so far, what is that for 6 months?
That is, I don't know when, from July 1 to January 11th. So essentially, yeah, for 6 months.
Okay, thank you.
Including another few hundred in juvenile court?
Right. So it's about 45%, 40 to 45% of what was formerly charged, I guess, Mr. Chairman.
It's more like 20%.
Well, I believe if it's 4,505, that's 9,000 a year, and 9,000 is of 26,000 is probably about. Okay, but 9,000 is about what, a third of 26,000. So okay. So
Okay.
it's a third.
Well, except, Mr. Chair, I think you also need to factor in, and there's no way to mathematically calculate this, but that's also 6 months of a pandemic where a lot of people are sitting at home.
And you don't really know where those tickets are being written either.
Exactly.
Yeah.
Yep, good point.
Okay, well,
Mr. Chairman.
Senator Servo.
Thank you. I believe Senator McDougal, who's now left for a minute, he pointed out there's another statute that ought to be included in that list I gave earlier, which was, I believe, on line 7959, section 4.1, 1117, delivery of marijuana or products to prisoners. That he thought that ought to be sped up. If we're going to speed up possession, that needs to be sped up as well. And Mr. Chairman.
Well, Senator Servo.
And I believe, hold on a sec. So anyways, I believe that's one discussion, and I'm not sure if we're done with it yet, but the other discussions we need to talk about is what to do about 18 to 21-year-olds and minors as part of that as well. We haven't, but I think that's we had to carve that off for a separate discussion before we finish where we are.
Okay. Well, are we comfortable with this, with what we've talked about, with possession of marijuana as of July 1 of 2021? If we can exempt these groups?
Mr. Chairman, I just don't know if you want to have the homegrown discussion separate or apart or what, or whether it needs to be talked about.
You're talking about, with the homegrown discussion, the whole idea there is, since under the administration's proposal as refined by the Rehab Committee, January 1, 2024, people will be able to have 4 plants, if we are going to speed up simple possession before we have the regulatory scheme and the agency set up, are we also going to allow people to have 4 plants as of July 1 of this year?
Correct, Mr. Chairman. Or do we ban homegrown until the retail piece is set up?
Right, I understand.
And Mr. Chairman, I worry a bit that we set ourselves up for a lot of chaos if we speed up the getting rid of the criminal infraction, but we let people grow a pound in their backyard without a retail structure in place or the licensing or a lot of the other things. It just seems to me it creates a lot of potential chaos and confusion if you can grow, up to a pound in your house, or if you have 6 people in your household like me, I guess I could grow about 4 pounds.
Mr. Chairman, I thought that was per household, not per person.
I think that's correct. I think it's per household. Senator Morrissey has a question.
Question for Senator Serville.
Sure, I'll yield.
Thank you. Do you believe that if we legalize the simple possession of marijuana, as Senator McClellan's amendment would do, that we're going to have a rush, an onslaught, a wave of folk growing marijuana in their backyard? Do you really think that's going to take place?
Mr. Chairman, what I would say to Senator Morrissey is I think there will be confusion as to what's allowed and what isn't.
Further question.
So I think there'll be some rush, a little bit, and you'll have neighbors like calling the police trying to figure out if they can do it or not. And
I understand. It's fair enough. Further question, Mr. Chair.
Senator Morrissey.
What is better, to legalize marijuana right now and thus prevent people that have historically been discriminated for possession of marijuana, black and brown community, legalize it now, knowing that there would be an increase in people producing some modicum or more of marijuana, or delay the simple possession of, delay the enactment of legalizing marijuana for 2 or 3 years so that we can get this very small sliver of those folk that grow marijuana legislated? If you have to take a choice, which do you prefer? Because that's where we are.
Mr. Chairman, I'm not sure I completely agree with the choice that the senator has posed. Because obviously, by choosing to completely legalize possession without legalizing distribution, we're already sending a mixed message. And likewise, allowing growing at home, which it sort of looks like possession, but it is on a criminal level difficult to prove when it's just sitting in your backyard. It creates, I think, opportunities for legal uncertainty and different results around the state, which can cause lots of headaches, attorney's fees, charges, differing enforcement approaches, et cetera. And I think there probably would need to be clarity for the police and for the courts and for people about what's allowed and what isn't in their backyard, or else you're going to have confusion and chaos. That's what I worry about.
Mr. Chair.
Senator McClellan.
I think we might be making this a little more complicated than it needs to be. In my mind, I'm trying to make the distinction between what we decriminalized effective July 1 and what I'm advocating for. That is what we legalize this year. As I understand it, growing in your backyard currently is not decriminalized. Is that correct? We can have the discussion that Senator Serville wants to make and decide whether we want to change that in this bill for July 1, but I don't see why that has to be tied to whether or not we legalize simple possession right now. So let's separate these discussions. And I think I hear, I mean, can we at least vote on the concept of one first before we decide whether we should go down the path of dealing with what's growing in the backyard?
We sure can do whatever the committee wishes, but from my perspective, if we legalize marijuana before we set up a legal structure to buy the marijuana, a legal marketplace, we are enabling a black market to continue to exist to a large extent, and subjecting people to criminal penalties when they sell marijuana, or we're telling people they can grow it at home.
Mr. Chair, but in effect, we did that already when we decriminalized. So I don't think there's going to be any more confusion going forward July 1 of this year if we legalize what we already decriminalized than there was at July 1, 2020. The only thing we're doing now is saying whatever we legalize, subject to the exceptions that we seem to have consensus around, no more fine.
Mr. Chairman.
Senator Servo.
Thank you, Mr. Chairman. I'd still think there will be confusion about what you can do in your backyard. Therefore, I think we need to have an explicit provision in the legislation that specifically prohibits home cultivation until it's otherwise legalized. I think that needs to be in the bill so it's clear what's allowed and what isn't. I would make that motion.
So it would continue to be a manufacturing issue under the law until January 1 of 2024.
Right.
Okay. So that motion's been made and been seconded. All in favor, say aye.
Aye.
Opposed? No. Okay.
Mr. Chairman.
Senator Servo.
Thank you. One other thing that we have to complete as part of this discussion, and I mentioned this to yourself and also to Senator McClellan, is the Department of Motor Vehicles brought to my attention that we need to make sure the possession inside of a commercial motor vehicle or a CDL context needs to be covered by this in order to retain our federal safety funds. And I believe Millicent Ford's online and can talk to about it.
I think we already talked about a list of bills that have to be excluded if we're going to go with Senator McClellan's amendment. If we're going to, and that was certainly one of them.
Which statute is that?
Weren't we also?
I'm trying to get through that list of statutes. That's why I brought it up.
Okay, I'm not sure which statute that was, but I thought
I don't remember talking about that statute. I'm not sure there is one. That's why I bring it up.
There's an amendment that's being prepared by the administration to deal with that circumstance.
Okay.
That was why I asked, Mr. Chairman.
Will that amendment be ready by Monday, Senator Evan?
I'll make sure it is. The administration's on the line. It may be ready now. I'm not sure.
Okay, is there anybody from the administration that's ready to address that issue?
I believe Millicent Ford is on from the DMV, Mr. Chairman, or she said she was going to be.
Ms. Ford, are you on the line?
Mr. Chair.
Ms. Ford, how are you doing?
Great. Mr. Chair, members of the committee,
We're trying to figure out this commercial drivers issue. Could you explain that to us a little bit about? Senator Serval says it's tied to some federal funding.
Can we get the volume up?
Right. The Federal Motor Carrier Safety Administration.
I can't hear, Mr. Chairman. Can we get the volume up?
Can you hear me?
Not very well. I'm sorry.
Can you hear me now?
We can hear you barely. It's just your volume is very low.
We just can't hear very well. You're not very loud.
Can you hear me now?
That's a little better.
I apologize for that. What I was going to say is that Federal Motor Carrier Safety Administration has advised BMV that Virginia would be invited.
We just can't hear you. I'm sorry.
Mr. Copenhaver is familiar with the situation. He may know about the amendment, perhaps.
Mr. Chairman, my understanding is that that Charles has the amendment.
Is that right, Charles?
I have a different amendment. I don't think it addresses the issue that Senator Serval is talking about, because the amendment I have deals with prescription marijuana for CDL drivers, not necessarily CDL drivers are possessing marijuana unlawfully, or in the case of, I'm not sure it's the same issue. If it is the same issue, then
Mr. Chairman.
Senator Serval.
Thank you, Mr. There are multiple issues wrapped up in this. And again, unfortunately, this isn't as simple as everybody wants it to be. But the question I have for DMV is, in order to retain our federal safety funds, do we need to have a marijuana possession offense where marijuana was in your possession while operating a commercial vehicle requiring a CDL? Or do we have to have a system in place that ensures that if somebody is convicted of possessing marijuana anywhere in the world, but they happen to have a CDL, that is capable of being reported? I'm trying to understand exactly what the requirement is that the federal government requires.
Okay, Mr. Chair, can you hear me now?
Hear you great, loud and clear.
Okay, great. I'm sorry about that. It would be a violation of the federal regulations if Virginia does not have a law that prohibits possession of marijuana in a commercial motor vehicle, and that includes prescription marijuana. And so those convictions would have to be reported to DMV to place on the record. It would not affect CDL holders who get convictions for possession of marijuana in their personal vehicle. It's strictly in a commercial motor vehicle violations.
And that violation's tied to our highway funding, our federal funding.
Yes, it's tied to our federal funding, and it's tied to our ability to issue commercial motor vehicle, our ability to issue CDLs.
Mr. Chairman.
Senator Serval.
Thank you. A bird has whispered in my ear that this is dealt with in the statute at lines 12,223. And so we need to add to the list of offenses that would become active earlier, the new 46.2, 341.20:7, lines 12,223 through 12,260.
Yeah.
And Mr. Chairman, that is what there's an amendment I have to that, which basically removes it says that the amendment is to remove the following language, which is unless the substance was obtained directly from or pursuant to a valid prescription, because as Ms. Ford just said, that prescription marijuana would likewise be a violation. So just removing that language from the language that Senator Serval wants to include in the amendment.
That's correct.
So, and that is on lines 12,225 to 12,227. See, starting at the unless and striking it basically through authorize the Drug Control Act. So that's what would come out. And that would then be incorporated into the amendment.
Okay.
The rest, new language.
Do we need to make that amendment then, or?
I think we can do it as a big blocky amendment,
Okay,
Mr.
okay.
Chairman, probably be better.
Okay, who's next?
Mr. Chairman, I can't think of anything else on the list relating to Senator McClellan's amendment, except for the issues relating to minors.
Okay, well,
And under 21-year-olds.
are we ready to make the big amendment then to exclude?
There is one other thing. In the current possession statute, in the special session, we did add language to that section that, and I'm not sure if it'll be a repeal or not a repeal, or however we want to look at it, dealing with essentially that no law enforcement officer may stop, search, or seize any person solely on the basis of the odor of marijuana. I'm not going to say I assume, but that language need to be retained, because if that code section is being stricken, I just want to make sure that the committee knows that that language would need to be retained in any situation.
It will need to be retained.
Mr. Chairman.
Senator Serval.
I would agree with, your judgment on that, Mr. Chairman, but I would also just point out that one other discussion we need to have is what to do about 4.11107, which is the open container law, which I think would probably also need to be dealt with, but that statute itself, I think, is part of a separate discussion.
4.11107,
Yes.
and where is that in this bill?
7,864.
7,864. Okay, what's your issue?
Well, Mr. Chairman, I think if we're going to legalize or not have an offense for possession, but we're eventually going to have an open container law, we need to speed up that open container law to July 1 of this year also. But this open container statute has some legal issues associated with it that I think we need to probably discuss.
Okay, let's discuss them then. What legal issues are you talking about?
Gosh, I'm trying to remember now.
Permissible inference?
Yeah, Mr. Chairman, Mr. Cushing talked about permissible inference yesterday, which I believe is consistent with Virginia case law as opposed to rebuttable presumption. But, Mr. Chairman, one of the other issues I had with this was that I think I'm trying to remember now, but I believe the way this is worded is that, like, if you got 4 people in a car and maybe they were smoking at a park or something, and then they start driving, all 4 people in the car get tagged with the permissive inference, even if the marijuana only belongs to one of them, and it isn't theirs, and but they still get charged with a Class 1 misdemeanor.
Does anybody else have an issue with that?
That kind of issue is usually right in Senator Morrissey's wheelhouse, but
Senator Morrissey does not have an issue with that.
yeah.
He says we've given enough stuff away today. We don't have to worry about that one. Okay, going once, going twice.
Well, Mr. Chairman, I think that at least needs to be added to the list.
Well, it needs to be added to the list because we need to create that offense July 1 if we're going to legalize the possession of marijuana.
Right.
That does. Okay, and there was an issue about people under 18 and those people that are 18 to 21.
Yeah.
That's
1104, I believe.
line 7806. Is that where we are?
Yes, I'm sorry.
Page 158?
70.
Sorry?
7806.
706.
Mr. Chair, it's line 7806, page 158 of 263.
Right.
No. No. That's the rehabilitation language. It all starts at line 7705.
7705? Yes, you're right.
Okay.
On page 156, you're right.
I guess that's for adults. Then the minors, I guess.
Mr. Chairman?
Senator Evan.
Are you all voting on Senator McClellan's, the reconsideration of her motion? This is just consideration as to...
Her motion was reconsidered. We're going to
Okay.
take that back up, and
All right.
we're going to amend it to take
all these things into
these
consideration.
things out and also to speed up the implementation of certain other statutes.
Thank you.
Such as the ones we just talked about.
So this is all part of that discussion, that motion. Thank you.
Mr. Chair, I believe the underage is in 44.11105.
Okay, I'm in the wrong place now.
And if you, it's phrased as if it's retail marijuana. That's essentially kind of follows the underage alcohol possession. So if you look,
What statute?
well, 4.1, 1105.
I'm sorry. So Senator Morrissey was right.
Mr. Chair,
Senator Morrissey.
first of all, let's just make sure that everybody is in agreement with the penalties for possessing more than an ounce of marijuana. And towards that, I have a question of Charles. Charles, right now, if an individual possesses, say, 5 or more pounds of marijuana and is charged with possession of marijuana with intent to distribute, what is the class felony for that behavior? Is it a class 5?
I know we amended it, so let me pull up what the. So more than 5 pounds is a felony and punishable by imprisonment of not less than 5 nor more than 30. 1 ounce to 5 pounds is a class 5 felony.
Currently?
Currently.
Okay. And I'm just pointing this out because we're getting into the weeds, no pun intended here. But right now, this is, if you look at subsection C, if you possess more than 5 pounds of marijuana, the sentence range is 1 year, 1 to 10, which is a 2 to 10, which is a class 5. Class 5 is 1 to 10, and class 4 is 2 to 10. Are we creating a problem by having a possession offense with that versus a possession with intent to distribute? I'm just posing that question and like your opinion on it.
Well, the current possession with intent would sunset when these new laws take in effect. So,
okay,
the extent that you're creating a problem that somebody will potentially face greater punishment now than they will in a few years. I mean, that's the situation that's being created.
all right. Now, let's get to I think that the issues that cause the folks a little bit more angst, Mr. Chairman. If we turn to page 158, line 7806B, we started to get into this the other day, and that is the penalty for the adult between the age of 18 and 21 who is still penalized, albeit a civil penalty, for possession of the amount of marijuana set forth in A. It causes me some angst that an adult who is 20 years old, all right, and is convicted under subsection A, subjects himself to a criminal penalty, but once he hits that, or she hits that magic age of 21, does not. I asked Senator Servo last time, was this language to conform with the alcohol laws, and I thought he said not necessarily.
Right. Mr. Chairman?
Senator Servo.
Thank you. One of the things that really bothers me about this is that underage possession of alcohol is a class 1 misdemeanor. You get 12 months in jail for a first offense, and under this, underage possession of marijuana is only a $250 civil infraction. So there's a significant policy difference there.
Well, there is, and I think Senator McDougal last year pointed out that some of the things we were doing were inconsistent. The way we were treating alcohol, frankly, alcohol, tobacco, and marijuana were all inconsistent. And we ought to, it seems to me, from a policy standpoint, we want to make them consistent because they basically, I guess people do them for the same sorts of reasons. I don't know if we can do that in this bill unless we're going to raise the punishment for marijuana. I don't necessarily think we ought to do that. But it seems to me that if we are going to, if marijuana, if alcohol is a class, possession of alcohol can be a class 1 misdemeanor for someone that's 20 years old, and that someone who's 20 years old can theoretically be drafted if we have a draft and serve his country, but he can't drink a beer legally. I'm not sure that we should just totally eliminate the criminal penalty for possession of marijuana for that 20-year-old. I think it ought to be treated more like, there ought to be, the criminal penalty makes sense for me.
Mr. Chair?
Yes, sir.
I
Senator
listened
Morrison.
very carefully to what you say. I would like to hear from Senator Eben or Senator Lucas. Is it their intent that a 20-year-old who is in possession of marijuana and it's his second offense, a month shy of his 21st birthday, where he would have, there's no liability, could be penalized up to a Class 2 misdemeanor, which is up to 6 months in jail? Is the way it's written right now,
Use the microphone.
Senator Lucas, the way it's written right now, a 20-year-old that is convicted of a second, of a second offense is guilty of a Class 3 misdemeanor, or a third or subsequent offense is a Class 2 misdemeanor, which is up to 6 months in jail.
Mr. Chairman, I will respond
Senator Lucas.
by saying that, yes, that's the way the language is written in the bill currently. And I think these are consequences that we did not originally intend.
Senator Evans got something.
Yeah, I just wanted to say, I think I would encourage the committee to consider what's the appropriate penalty to discourage use without, clearly there needs to be a look at alcohol and tobacco, and I'm happy to put in a resolution of that study next year, but this is we should get this right.
Correct.
And I'm sorry if it won't equal all substances equally, but I'd rather see a punishment that's a fine and perhaps, if it's under 18, an education course.
Exactly.
Mr. Chairman.
Senator Servell.
I mean, I know this is inconsistent with what we're trying to do, and with what Senators Lucas and Evan want to do, and I probably with Senator Morrissey, but it seems to me that the discussion about whether underage possession of substances ought to be a Class 1 misdemeanor or a civil infraction is probably for another day, because that's a longer discussion. I wouldn't be surprised if there's some federal safety monies tied in there somewhere. Maybe Millicent could enlighten us on that, but I would suggest that we make them consistent and that underage possession be a Class 1 misdemeanor. Even though I don't like that, I don't like it at all, but I do think that it's what we ought to be consistent, and then if I think for maybe a different bill, a different year, we take them both down. But for now, I think it's important that we be consistent instead of saying, if you smoke marijuana, it's just a fine, and if you use alcohol, it's a crime. I mean, to me, it's important that we be consistent.
Senator, Mr. Chairman.
Senator Morrissey.
Senator Servell went in the opposite direction that I wanted to go
I know.
into for the
I did.
purposes of being consistent.
Right.
With possession of alcohol, I actually want to be logical. And I just need Senator Servell to explain to me why somebody who is 20 years and 11 months that has his whatever offense of possession of marijuana, he is 1 month away from being able to possess all the marijuana he wants, up to, what I'm talking about, pursuant to subsection A. But if he's 1 month shy of 21, you want to now make it a Class 1 misdemeanor.
Mr. Chairman.
I don't think that's the intent of
Senator
the stakeholders
Servell.
in this bill.
Senator Servell wants to respond.
Yes, sir.
No, I ultimately don't want to do it, but I think we do need to do it in order to be consistent. And I think that whether or not underage alcohol possession should remain a Class 1 misdemeanor is a discussion we need to have. What I don't know sitting here right now is whether or not by taking alcohol down to where we have marijuana, we create a problem for the DMV or the Virginia Department of Transportation or somebody else, which is how these things often work. That's what I worry about. And it just seems to me that if we have two inconsistent penalties on the books, that doesn't make any sense.
Okay, I'm going to make a motion, Mr. Chair.
You are free to make a motion,
Thank you,
Senator.
Mr. Chair. On line 7806B, 7806B, I want to put a period after, go all the way down to 7807 after $250. So it will read now, any person 18 years of age or older who violates subsection A is subject to a civil penalty of no more than a $250 fine, period, full stop, delete the rest of the sentence. That's my motion.
Is there a second for that? There's no second. Here's my, from my perspective, I don't know that there's a consensus in this subcommittee to raise this to a class 1 misdemeanor. I don't know if there's I think there will probably be 2 votes for that and 2 votes against and maybe 2 votes that are up in the air, but I don't think you're going to get you're going to get a majority for that, and I don't think you're going to get, I certainly don't think you'd get a majority to go to a $250 fine. My sense is we leave this where it is, and we come back maybe next year with a bill to equalize the penalty between possession of marijuana and possession of alcohol.
Mr. Chairman.
Senator Servo.
Thanks. Well, if that's what Mr. Chairman's recommendation is, and obviously this is subject to the Judiciary Committee, the full floor, and the other body, and the governor, but it seems to me that we need to adopt or make effective immediately all of 4.11105 from line 7806 and through some other word, but I can't tell where because there's a lot of other surgery that has to be done in order to make it consistent with the legal reality we're creating.
If you're saying that to make that as a part of Senator McClellan's amendment.
Correct. We have to have some kind of an underage possession offense in here, but in order to create a statute that's consistent with the intent of what she's trying to accomplish, this statute needs to be rewritten. And so we need to have probably a section of 4.11105 that's only effective, immediately, but, or July 1 until something else. But Mr. Chairman, there's a lot of other stuff in here that needs to be taken out and adjusted in light of that. There's a drug offense. There's a fund the money goes to, which isn't going to exist. There's some stuff in here about using a fake ID to buy marijuana. I think there's.
So in other words, Senator McClellan's amendment is going to cause us to rewrite the whole daggone bill.
Just this one section.
Thanks a lot.
Okay, Mr. Chairman.
Senator Morrissey.
Why can't Senator McClellan's amendment simply address the legalization of marijuana for people 21 years of age or older?
Well, I think that's part of what Senator Servell's trying to do. He's trying to exclude certain language or from the bill or speed up penalties. Is that correct, Senator Servell?
No, Senator Servo is concerned about the underage, meaning not just under 18, but under 21. And I agree with you, Mr. Chairman. Since there's going to be several iterations by the time this gets to the governor, I don't want to undo all the hard work that's already been done in bringing this to the stage where it is now. And I don't see that we're doing that if we limit Senator McClellan's amendment to those. Senator Stanley's leaving, Mr. Chairman. If we limit it to 21 years or older.
Mr. Chair,
Senator McClellan.
under current law, if someone under 21 simply possesses marijuana in the amounts under the simple possession bill, is that a $25 fine?
That's a $25 civil penalty. Yes, ma'am. Not even a fine.
Then why don't we just leave it at that? And for everyone over 21, that's what my amendment be limited to.
Mr. Chairman.
Senator Servo.
I agree with that, but that's not really my issue, and that's easy to fix. The question is there's a whole bunch of other paragraphs under here about treatment and community-based probation and subsequent offenses and rehabilitation and education that are in the ultimate bill.
Is that in current law?
Probably. It is for alcohol.
No, Mr. Chair.
Senator McClellan.
When we decriminalized, I don't think we need to make this overly complicated. When we decriminalized, we didn't add all the other stuff that is now in the bill.
That's correct.
Okay.
If we want to make a distinction between under 21 and over 21, let's keep in mind that right now, if you're under 21 and you use, it's a $25 fine. We don't have all this other stuff yet.
That's right.
So let's keep that status quo until we can get the law that Senator Servo wants going forward, and just say over 21, that's now legalized simple possession. That to me seems like the simplest way to do that.
Mr. Chairman?
Senator Servo.
I would agree that it's simple, but then it seems to me that if you want to keep the present reality of post-conviction treatment, et cetera, then all this language from line 7811 through line 7837 should never be adopted, which I might be fine with if I think about it for a minute. But right now, if we don't put people between 18 and 21 into a rehabilitation program, make them go do treatment and all this other stuff, I don't know why we're going to make them do that 3 years if we legalize retail sale.
Well, if you want to have a sooner enactment date for that, we can, but it sounds like you're saying we have to completely rewrite something. What you just said sounds like we need to take something that's already here and just accelerate it. Is that what you're saying? Or you're saying we need to write something new that is not here and accelerate it?
If we want to affect what you were suggesting a moment ago, your proposal, I think, we would only accelerate lines 7806 through 7810, pretty much, and change it to a $25 fine, roughly, okay? I think you said that's more or less consistent with present reality.
Which I said 20 minutes ago, but I had $250 fine and there was no second.
Right. Well,
Yeah,
sort
exactly.
Do that again and I'll second it.
Okay, but my point, but listen,
that
but my
again,
point,
I'll
but my point is that under this bill that the governor's proposed, that Senator Eben and Lucas are carrying, we're mandating a bunch of treatment and education and stuff for 18 to 21-year-olds that we currently don't do today. And I don't know why we would delay that, but we could, I guess. But that's my question.
You don't know why we would delay that if we are going to allow legal consumption on July 1.
Right.
Okay, well, if we want to accelerate that going forward, that's fine.
Right. My only point, Mr. Chairman, was if we want to use any of the language between 7811, it starts getting complicated around lines 7831 through 46. There's some surgery that has to be done because there's stuff in there that doesn't exist until the rest of the bill goes into effect. That was the point I was making.
I would just wonder, and I don't know whether anybody can answer this, whether if you accelerate that part of the bill, whether that has a fiscal impact.
Probably. And that's why I think we should keep this as simple as possible. Whatever is ready to go now, July 1, let's do July 1. If we need more time to get it right or get funding in place, then we delay it. It may not need to be delayed to 2023, could be sooner. But I think my point is we should just do what we can do now.
Mr. Chair, so I'm just trying to, I guess, put a somewhat of a fine point on this. A lot of the sections in obviously 4.1 that Senator Servo is referring to take place in a regulatory scheme that does not exist. So it wouldn't be accelerating it, because if we accelerate it, you'd be accelerating it in an area that there is no regulation for. So we would have to import these sections into the current or move them into 18.2 because that is the only current scheme we have for marijuana. They couldn't exist outside of current, I don't want to say criminal law but the Title 18.2 because there is no regulatory scheme in 4.1 for these to really exist. Now, to the point that Senator Servo is making, and I think what he's trying to say is there are some provisions in the new regulatory scheme that create criminal penalties that do not currently exist. Because currently and this is where I think the DMV issue becomes particularly relevant, is under current law, possession of marijuana is subject to a $25 civil penalty, which for DMV purposes satisfies their requirement because the penalty that is in the new bill is a $25 civil penalty. So if you were to decriminalize, if you were to, what I would say is make marijuana, eliminate the civil penalty for anyone over 21, that is probably the only thing you would need to make sure you're including to satisfy the DMV issue. In terms of everything else for the juvenile piece, if you like the policies in the current bill, you could fast forward them or advance them to the July 1 date. But if everyone agrees you do not like them, we can just strike them from the bill so they wouldn't take effect in 2023. And that's a policy consideration for the committee.
Mr. Chairman.
Senator Servo.
And again, it drives me nuts in terms of consistency that we would say if you're 19 and you get busted with marijuana, you don't have to do a program. But if you're 19, you get busted with alcohol, you got to go to classes and community service. I mean, but because that's what we're setting up if we don't include some of this language under here. And, again, I'm not sure I agree with the alcohol, what we do for alcohol now. But it seems to me that fight's a fight for another day. And in the meantime, we make them as consistent as possible and then have that fight later.
I agree. My sense is that part needs to be consistent. So what's your pleasure?
Mr. Chairman, I think for the time being, to me, again, that requires a couple organ transplants, right? And for purposes of subcommittee work, it seems to me that perhaps right now, provisionally, we speed up 7806 through 78. The first sentence of subsection B, which I think is most of Senator Morrissey's motion. And we agree to work on the rest as this moves. Maybe Mr. Qualiato can have an amendment for committee that we can look at to make them consistent. Does that make sense, Mr. Chairman?
In the interest of moving this ball forward, sure.
That's what I'm talking about.
Yeah, let's just, yeah.
You understand, Mr. Chairman?
I do. I was hopeful that we could get we could leave this subcommittee with a substitute that would incorporate, if we're going to go with Senator McClellan's amendment, go with that and go with the things that we are exempting and the things we're fast tracking. But it sounds like you want to just draft a series of amendments, and then when we.
What I heard him say is we are accelerating the lines that he just said as part of the subcommittee. And if we need to tweak that, just that section in the full committee, we can do that. Is that what you said?
Right, Mr. Chairman,
But we're also accelerating or exempting a lot of other things if, to accommodate the July 1, 2020 date.
Mr. Chairman, here's my point, is I think whatever the statute is for underage possession and the treatment scheme or whatever, it's going to require a lot more surgery than we can do in committee right now today, and it might be it's something we have to tee up at full committee or maybe on the floor as a floor amendment to the ultimate bill. I think it's something, I think at least it sounds like you and me, Mr. Chairman, agree on trying to treat alcohol and marijuana consistent, but actually accomplishing that in the subcommittee without words in front of us, I think might be kind of difficult to get done today. But I don't want to just get stuck on this forever, given the other things we need to talk about. But I think we have an agreement in concept, but we just need to do some things to get something for people to look at.
Well, it's 4:15 on Friday afternoon, Senator Serval. I mean, what else do we need to talk about?
We haven't talked about what to do about juveniles yet. And I know there was some discussion about treating juveniles through the CHINS process as opposed to through the delinquency process. And Mr. Chairman, I don't have good judgment about it, but I know there's a lot of people who feel very strongly about it. I don't know if there's anybody on the line that could explain the trade-offs of doing that, but that's something I'd be interested in hearing to decide whether or not which direction we ought to take.
Is there anyone from the court who can discuss with us the differences between a CHINS, treating juveniles through a CHINS process or through a delinquency petition?
Mr. Chairman, when they do speak to that, is it just for possession or is it like under the influence? Because certainly like with alcohol, you have possession of alcohol and then driving under the influence of alcohol. There's driving under the influence of alcohol as a juvenile, which is a separate penalty than driving under the influence of alcohol. So it's two levels.
Different levels, different
there.
standards for under.
So are you gonna, if somebody's driving after consuming marijuana, is that gonna be?
I think that has to be
same?
considered. That has to be part of the process. Eileen, you were just about to say something.
Yes, Mr. Chair. I think the problem is I'm not sure we're the best staff to address CHINS petitions. That really is another one of our colleagues. I could not address it with any sort of knowledge without really looking at the issue deeper. I apologize. I just don't think we have a couple of staff on here and I just don't think we're in a position to talk about that.
Mr. Chair, I think someone from the administration
Okay.
answer that question.
Yeah. Yes, ma'am.
Yeah, Mr. Chair, members of the committee, we have Laura Todd from the Department of Juvenile Justice, who is really well versed on this issue. I believe she might be in the waiting room, if it's possible to let her in.
Okay. Laura Todd's and Megan Fields' box on the screen.
And I'll start the video just so that it doesn't like I'm talking from nowhere.
We got you.
All right. And you guys wanted a little bit of maybe background on the distinction between CHINS and how we deal with maybe alcohol, tobacco, and marijuana?
We were trying to figure out from a policy standpoint whether we want to proceed with a CHINS petition or a petition for delinquency for someone who's under the age, and we want to consider possession. We want to consider people that are under the influence, people that are driving under the influence as well.
Well, I will just start by saying that CHINS, when we're talking about CHINS services especially, is really meant as a more holistic approach. It's really addressing sort of basic behavioral issues. It doesn't have really anything specific in it at current. It's about an individual who needs services, is a danger to themselves, and the dispositions are such that it's pretty, it's very general, and it's meant to give the court the opportunity to change some custody or placement options, as well as order programs, education. It's a general, things aren't going well, but there isn't something that's, like a delinquency matter that's happening, because those are really addressed more specifically. So it's a lot of times kid is not controllable at home, right?
Mr. Chairman.
Senator Servel's got a question, I think.
Well, sort of. And Mr. Chairman, her description of a Chin's petition is consistent to the one or two Chin's cases I've handled through the years. I just know there's a group of advocates that believe Chin's is a better way to deal with this rather than delinquency. But I've also, while sitting here, and after we've teed this up, been getting numerous messages in my phone about claiming that we had this discussion last year and that we made the decision to leave it in the delinquency side as opposed to the Chin side. And I'm sort of wondering whether maybe that's a discussion for another day in another bill instead of trying to figure that out right now.
Second.
Okay, thank you so much, but that's, thank you, Ms. Todd. Thank you. Just leave the room.
Mr. Chairman.
Senator Servel.
Thank you. So now, given where we are with, I think, the big blocky, whatever motion it is we're developing here, I also have a question as to whether or not we've covered underage possession or not, because the language that we adopted under from subsection 4.11105 only deals with people 18 years of age or older. And so I'm curious if we need any other amendments to make sure that juveniles are covered by what we're talking about. I guess that's a question for Charles.
Charles, did you understand the question?
I did. So, Mr. Chairman, that section on subsection C addresses juveniles. So on line 7824, any juvenile who violates subsection A is subject to a civil penalty of no more than $200 for the first offense. And then it goes on to treat the child delinquent, and any second or subsequent offense is guilty of a class 3 misdemeanor. So that is the way the bill deals with persons less than 18 years of age.
Okay, Mr. Chairman, then I think we also need to include that in this block motion. So lines 7824 to 7830.
Are you keeping a list of all of these things that are going to be accelerated or exempted, Charles?
I am trying to as best I can, Mr. Chairman. I think most of them I may need to recap when we're all wrapped up just to make sure I have everything.
Okay. What next?
We're getting there. Oh, Mr. Chairman.
Senator Servel.
Again, I would really like not to make this as complicated, but
it is complicated.
There are, to my memory, between 8 and maybe 15 exceptions for which juveniles can possess alcohol. And again, if we're going to be consistent, I mean, I kind of wonder if we need to incorporate some of those exceptions into the juvenile possession situation.
Mr. Chairman?
Senator Eben.
Yeah, aren't those exceptions for things like religious ceremonies?
Yes.
But I don't think that marijuana falls into that, or cannabis does fall into that.
I would disagree with that, Senator Eben. But, Mr. Chairman, it's not only that. It's, I mean, parents are allowed to let their children drink alcohol. That's actually allowed under our code. And parents are allowed to let their children carry it. They're transporting it under the code.
Just to be clear, I'm not advocating for parents to allow their children to use cannabis or to carry cannabis.
Senator Servel, that's your issue?
Yeah, I get it. All right. I guess we can move on from that. I'm just telling you, like, I know that in alcohol possession, there's about 15 circumstances juveniles are actually legally allowed to possess alcohol. I know all of them aren't applicable to marijuana, but I haven't even begun to do the comparison. But if we're going to be consistent, that was an issue I thought needed to be discussed, but I guess.
Maybe what I would suggest is that maybe you can come up with that comparison over the weekend and come to the committee with an amendment.
All right.
Are there other issues that people want to take up? Before we get Charles to run through the list of things he's written down.
I only want to legalize juvenile possession in Hanover County. How's that? I'm just joking.
Don't come to Hanover. After all this junk that's coming out of here, that might not be a good idea.
Okay, Charles, maybe if you could run through the list of things that we have exempted or moved up?
Okay, Mr. Chairman. So if I am to understand the suggested amendment, it is to eliminate criminal penalties or civil penalties for simple possession of marijuana for anyone over the ages of 21. For persons under 18 years
Sorry,
of
Mr. Chairman, and paraphernalia,
and paraphernalia.
265.3.
Right. So for persons 18 years of age or older, it'll be a civil penalty of no more than $250, period. And then for juveniles, so if I understood Senator Morrissey's earlier amendment was just basically to strike everything after the $250 fine. So there is no second offenses, there's no court order treatment. It's just a straight $250 fine.
Did we agree to that?
Yes, we did.
I think so.
I thought he made the amendment, but nobody, it wasn't seconded.
He made the amendment, we didn't accept it, and then when we went back and talked through it, I basically said, I think he was right, I think is what happened.
Is that an amendment? I'm just,
Okay, leave it in there.
all right. But I am fast forwarding that language on lines essentially 7 and 806 down through 7830, which deals with persons 18 years of age or older and for juveniles for simple possession. That's going to be the new current simple possession penalties for persons under 21 in kind of in toto. The next thing is, and I'm just addressing this because I don't think there was a motion on it. It is not including the open container is going to exist as is. There wasn't an amendment to advance that.
There was not.
No, I thought there was an amendment to advance it. There was no changes to it.
Okay, that's right. We were advancing that. That's right.
Okay, all right. Advancing the provisions in 4.1-1108, the consumption in public places.
Okay,
Advancing 4.1-1109, consumption on public school grounds.
okay,
Advancing 4.1-1110, possession or consumption while operating a school bus.
yes, sir.
And 4.1-1112, the possession of marijuana while driving a vehicle for hire.
Okay,
And then it is then also advancing the CDL provisions located in 46.2.
okay.
Mr. Chairman, Mr. Quagliano missed 4.1-1117, which Senator McDougal suggested delivery of marijuana or products to prisoners.
And I was looking at that, and I'll double check. If that is not currently included, I will include that. I just want to make sure that's not already currently covered. But yes, if it's not included, I will definitely advance that as well.
Okay, that's the entire list?
That is the entire list I have.
Okay, is there anything anybody else has?
Mr. Chairman, I scribbled down 46.2, 341.20:7. Was that one of the ones you just mentioned?
It is not. Can you repeat that?
The CDL one, I think that was 46.2.
Yes, that is the last one I mentioned, the one in Title 46.2.
Yeah, okay, got it.
Okay, you're going to prepare that. That is a series of amendments along with Senator McClellan's amendment.
I will try and prepare it as amendments. I will try and prepare them as amendments.
Okay.
Mr. Chairman.
Senator Servo.
And I mean, again, it seems to me that I don't know whether you think it's within the purview of this committee or not, but I mean, as for the rest of this, there's a lot to talk about, and it strikes me that the rest of this perhaps needs everything else needs a reenactment clause or something, because there's a lot of legal issues that are probably within the purview of this committee that are wrapped up in the rest of the bill that I don't think we have enough weeks to talk about.
And Mr. Chairman, there is as an aside, I believe there is a technical amendment that needs to be made on line 12,946. It repeals a code section 18.2, 251.1. Not sure if that was intentional or not, but that code section deals with, I want to say, marijuana in maybe it was possession of, now, I think I might be incorrect. I think that's okay.
Okay.
But I think it was the wrong code section.
Let's deal with the issue you just raised in a second, Senator Servo. First, in connection with Senator McClellan's amendment, do we readopt her amendment along with all the other proposals that Charles just went through?
I'll make that motion.
Okay. Is there a second?
Talking about McClellan's motion.
I'm making the motion to do what McClellan wanted to do with all those other things added to it.
Second.
Okay. The motion is to go back to July 1, 2021 with all the things that are exempted or the things that are accelerated that Charles just went through as a series of amendments. Do you understand the amendment? Any further discussion? All in favor say aye. Aye. All opposed? Okay.
Senator Stanley also, and Senator Edwards votes aye.
Senator Edwards votes aye. That amendment is passed. Now the issue you just raised, Senator Servo, you discussed a reenactment clause on the rest of the bill.
I have.
And that's the part that we didn't get to actually work on much at all.
Mr. Chairman?
Senator Eben.
Just to bring up one other, which if there is a reenactment clause added, you may not want to deal with it today, but I just want to call to your attention on the side-by-side I prepared for you, the fourth topic down was adult sharing, meaning that in private adults, this would be after there's a legal market, allowing adults to share small non-tail transfers within a private residence, not in a public space. I know they had that in the version on the other side. Basically, if you give a friend marijuana rather than buying it through a licensed dealer, that would be legal. But I don't know if you would want to do that until the product is legal or not.
Well,
Kind of like a craft beer club.
Well, or just just giving someone, sharing it with them. Yeah.
Okay. Well, let me, so I want to ask you, Senator Eben, if we legalize marijuana possession, simple possession as of July 1 this year, under Senator McClellan's amendment, and put a reenactment clause on the rest of the bill, so that it basically gives us another year to figure it out, how does that affect what you want to do?
It would be either sharing a product that's not been regulated, but it would be not an illegal product. So I would think the committee may want to consider it. Otherwise, it would be a crime to share marijuana. If someone gives it to someone else.
How would it be a crime? I'm sorry, Mr. Chairman. How would?
I think it's 4.1-647 in this bill. Let me see if I can find the page.
I don't think he's addressing the reenactment issue at all. It seems,
the reenactment?
Yeah.
Well, it would delay the development of the legal market to to for reenactment of the rest of the bill, the regulatory framework.
It seems to me that if, of these approaches, the approach the House has taken, apparently, to add in language allowing small non-sale transfers between adults of legal age within a private residence, not to exceed 1 ounce or equivalent. The public transfer is a Class 4 misdemeanor. If we're going to make any change at all, that's probably the one that makes sense right now. What do you think?
I'm sorry, could you repeat that, Mr. Chairman?
Well, look at his chart.
I'm there.
In the second column under the House bill, that approach looks to me to be preferable to the others.
We're on adult sharing?
Adult sharing in private residences.
Mr. Chairman, I assume that the reason this language is necessary is because to make it clear that sharing is not akin to a bartering or a sale, because sale is legalized, whereas if there's nothing on the books that criminalizes possession of small amounts, trading small amounts would also not be a crime at all. My assumption is that language became necessary because of the retail market language, not because of, not otherwise. I mean, if you decriminalize, I mean, if I share a pen with you, if I give you a pen, you give me back a pen, there's no crime there, which is effectively what a small amount of marijuana will be.
Your point is that there would be no need to change this until we've got a legal market.
Right, correct, Mr. Chairman.
Okay.
I think that's right. Maybe ask Charles if he agrees with that. But.
Charles, did you understand that?
I would agree with that. That would be my understanding as well.
Okay, well then we've got at least a couple of years to think about this issue.
Mr. Chairman.
Senator Servell.
Thank you. One other issue, which I don't think we've actually specifically clearly discussed, however, is that if we speed up, to follow on the McClellan, whatever motion it's become now, I think another thing that we also need to do is accelerate, well, I don't know if we can accelerate the expungement or how that relates to the expungement, but given that we've sped up
Senator Servell, the testimony that I recall from the Supreme Court in the past.
Oh, it's complicated and takes a lot of time.
Is that it will take at least 4 years to make the technological changes to do automatic expungement. So
got it.
Okay.
Thanks for refreshing my memory,
Mr. Chairman.
Senator Evan.
Would this committee then be recommending expungement to begin with this bill, or is that something that you're going to address?
Well, that's just the point Senator Servell was raising. You know, expungement, automatic expungement for marijuana convictions is part of this bill. But the reality is, and you may recall from this past summer and fall, is we heard from the Supreme Court that it will take 4 years to develop that technology.
Mr. Chairman.
Right, but we need to tell them to start developing it.
It's in the bill.
Yes.
It's in the bill.
That's correct.
Senator Servell.
Thank you, Mr. Chairman. In light of that, what I would then propose, and perhaps Charles could prepare this for Monday, would be that we add language to the expungement statute, that is 19.2, 392 point, I believe it's 2, effective July 1, that says if anybody chooses to file a petition-based expungement of either marijuana possession or paraphernalia relating to marijuana, that the court shall expunge that if it's filed by petition. So the discretion is removed, and that's effective July 1, so that if somebody wants to take care of it now, before the automatic kicks in, they can, and the court has no discretion about it. I would prefer to do that so there's no confusion about whether a court can or should expunge that type of conviction, Mr. Chairman.
And you would need the petition-based expungement right now, and you will probably until the automatic expungement is available.
Correct, Mr. Chairman. Charles, do you understand that?
Mr. Chairman, I see Eileen has her hand raised, so she may have a
Okay.
point to raise.
Mr. Chairman, we can do that if it's the petition process. We can do the petition process July 1, 2021. I believe, unless I missed it, the enactment clause 4 includes the automatic expungement provision with the July 1, 2021 date. So I believe the enactment clause would need to be changed so that the automatic expungement is not effective July 1, 2021. We can do the petition part.
Well,
And
am I correct that it's going to take several years for you to get the technology in place to do automatic expungements?
part of the issue is that, as I understand it, the state police have to change and even buy multiple systems before we can even start working with state police to implement and to develop this electronic communication piece. So it is very much dependent. We're interdependent with state police on this. It's my understanding, because of the discussion with the automatic expungement bill during the fall, that state police needs a couple of years to purchase these products and get those into place before we can start working with them to create this new electronic piece. Okay. That's my understanding of the issue.
Well, then would it make more sense, Charles, to put Senator Servel's amendment in enactment clause 4?
Mr. Chairman.
Senator Servel.
Mr. Chairman, I think we would have to adopt a specific revision to 19.2, 392.2 that's effective immediately, and as opposed to an enactment clause.
Okay, well, that Senator Servel's amendment, Senator Edwards has seconded it. All in favor say aye.
Aye.
Opposed? Okay, we're going to have to change the enactment clause 4 because the automatic expungement process will not be up and running until at least, well, as I recall from this past summer, the discussion was 4 years, but I think I heard Eileen just say it could be as early as 2 years. If we say 2 years and we're not going to get it done, then we can always change that. So why don't we amend enactment clause 4 to say that part is effective July 1, 2023? Does that make sense? We can always change it.
Mr. Chairman.
Senator Servel.
Again, what I was trying to raise a minute ago before I revisited the expungement discussion, though, was whether or not we want to put a reenactment clause on the entire bill, talk about doing that in this committee, or whether we want to save that debate for Monday.
If you want to make the amendment, you can certainly make that amendment now.
I would make that amendment now, Mr. Chairman. And speaking to that,
Senator Edwards will second it for the sake of the discussion.
thank you, Mr. Chairman. I mean, obviously that's obviously a huge discussion, and it seems to me a little. Some people might see it as presumptuous for this little subcommittee to make that recommendation, but given what I've seen, having now spent I think 12 hours in subcommittees trying to figure out some very small parts of this bill, that this thing is a 1,000-pound monster with tentacles that reach everywhere, that have consequences all over the place, and it's very.
Let me ask you this, and I agree with you, but are you willing to say that the Senator McClellan's amendment to speed up legalization will occur on July 1, 2021, and the amendments we just made to accelerate certain things or exempt certain things from that part will be effective, and the rest will be the rest of the bill would require reenactment?
That's correct, Mr. Chairman, just like we did with casinos.
Okay. Okay, Senator Servel's made a motion. Senator Edwards has seconded it. Is there any further discussion? All in
Chairman?
favor? Senator Morris,
Eben.
Eben, okay.
I would just point out that the regulatory structure is going to take several years to put in, and that we wouldn't start with the reenactment clause. That'll just be another year. I guess that's his intent.
Well, the intent is to make sure we have the language right. You look at this, I mean, this is a 263-page, 13,000-line bill. I mean, in your legislative career, how many bills this big, of this kind of import, and this?
Not of this import, I've not seen.
You've not seen them. I mean, we want to make sure we get it right. It seems to me that if that takes a little bit of time, That's all right with me.
Okay, thank you.
Do we have any further discussion of that motion? All in favor, say aye.
Aye.
Aye. Opposed? Okay. The bill before you with the amendments, is there a motion on that?
Chairman, I would move to recommend to the full committee that we report and re-refer the bill to finance as amended by this subcommittee.
Okay, we've got a motion and a second. Is there further discussion or additional motions? If not, I don't know if you, all in favor say aye.
Aye.
Opposed, no. Okay. 2 noes. The bill's reported and are recommended to be reported and re-referred.
Mr. Chair, just purely housekeeping. Is the purpose of having the amendments to make them severable only because in trying to conceptualize what these amendments are going to look like, it would be easier to draft it as a substitute with the idea of I can remove any amendments from the substitute and I can highlight any amendments.
Charles, that makes sense to me. When I said separate amendments earlier, I wasn't sure where our discussion was going. And I thought it made sense for them to be severable, but I think it makes sense now for us to have a substitute.
All right.
I agree that it's way too much, way too complicated to have to go through every amendment line by line when we get the full committee. And we've had a full discussion here. We've had public input. We should be able to just be able to present the bill and have a vote. Thank you very much. We'll rise.
Thank you.
Thank you.